The Supreme Court certainly dominates the headlines.
The Dan Yorke State of Mind program is brought to you in part by Lookout Rhode Island and Takeo Comfort Solutions.
Great to have you in. Thanks very much for tuning in. Obviously, there were some developments this week with the Senate the Democrats in the Senate trying to make a move on sticking everybody with a label on this abortion issue, correct? But tonight we're going to kind of go backwards a week and a half or so and come back to real time on what's going on with the potential turnover of Roe v. Wade. So thanks very much for tuning in. It's great to have you aboard. We're going to stay on a single issue tonight because the conversation is detailed, and we got a really smart person to deal with us on this particular matter. Associate Dean and Professor at the Roger Williams Law School, Jared Goldstein, is with us. In fact, he's in the story we're about to show you. Obviously, the headline is one that everybody has seen. This notion that a draft was released is not only peculiar, but perhaps unprecedented in the nature of it anyway. Let's remember what happened first week and a half, 2 weeks ago.
An unknown source takes the lid off a Supreme Court draft to overturn abortion rights, causing nationwide protests and uproar to overflow.
There's a very strong culture within the court not to leak inside information. That's why it's so unprecedented.
The unprecedented revelation is the first time a draft decision has been disclosed publicly while the case is pending. The draft opinion is not final and could look different during the final vote, but at this point, Politico is reporting a 6-3 supermajority in favor of overturning the 1973 Roe v. Wade case. Roger Williams University law professor Jared Goldstein tells me the almost 5 decades old case, paired with the ongoing heated topic, makes this unlike any leak in history.
A full-blown draft opinion before a case has been released in one of the most important cases of the decades, I think it will cause huge turmoil within the court.
Goldstein says this undermines the trust between justices and all court staff.
The justices know that the decision is going to cause a firestorm of protests. They know that people are going to be very angry about it, that they know there's going to be a lot of reaction to it. So the fact that there's some reaction now, to the leaked opinion, I seriously doubt is going to change their minds about what they're going to do.
Yeah, I mean that's one of the questions that we have in all of this, is whether there was motive to change things. Jared Goldstein is with us. Thank you very much for joining me. You did a wonderful job with me on the radio the other day, trying to walk me through this whole thing in real time. So we are a week and a half past the breaking news, and of course there's a follow-up that we'll get to later in our conversation about what the Senate was going through yesterday. Let's start from the beginning. Gut check on the news. Say it happened yesterday. What was your immediate reaction to it?
Well, I wasn't at all surprised to find out that the Supreme Court was poised to overturn Roe versus Wade. Anybody who's been following for years knows that that's the direction that they've been headed in, especially with the recent appointments of Justices Gorsuch, Kavanaugh, and Amy Coney Barrett. And then when the court took the Mississippi case this last year, I think the writing was more or less on the wall. And the only question was, were they simply going to affirm the Mississippi law and find that it was constitutional to ban abortion at 15 weeks, or were they going to go all the way and overturn Roe versus Wade? And when you listen to the oral arguments, it seemed clear that there were 5 votes to overturn Roe. So then when the leak of the draft opinion by Justice Alito came, I wasn't surprised that there were 5 votes for it. There were several surprising things about it, though. First, that there was a leak at all. That was shocking. That is, there has never been a leak of a full draft opinion in any case that I can think of, or that anyone has been able to identify, let alone a draft opinion in one of the most important cases the court's going to decide.
Yeah, I want to talk more about that. People don't know, though, that there was a mini leak back in the original Roe v. Wade. You're a historian of the court.
Yep.
You've been before the court. You, I'm sure, have touched base on this with your students. Either people forget or they don't even know that there was a mini leak, right?
Yeah. Justice Douglas wrote a memo after the argument in Roe versus Wade, and that got leaked and eventually ended up in the New York Times, laying out his view of the case, and there was some advance word about what the vote in the case was going to be. And there are other leaks, that have happened on the court over the years. Sometimes, rarely, what the decision is going to be. Sometimes, more often, a leak about what the internal deliberations look like. This happened in the big Obamacare case over the Affordable Care Act a few years ago, when we found out that Chief Justice Roberts switched his vote at the last minute and changed from voting to find the law unconstitutional to finding it constitutional on his own theory. But that happened after the opinion was out. So there are occasional leaks from the Supreme Court, but I don't think anything exactly like this, where a full draft opinion, a month before the decision was out. Although, as you saw me say in that clip, I think the leak is today's news, or it's this week's news, and we'll be talking about it, and it is very important for the internal workings of the court. But next year, no one's going to be talking about the leak, and in 20 years from now, no one's going to be talking about the leak. What they'll be talking about, is what the court did about abortion, which has, significant implications for all of our lives and for, the tenor of life in America.
Stay with me on the leak, though, in terms of the court security, precedents. Well, precedent would be the wrong application here. Worry about it impacting future processes and decisions. A bad habit that culturally develops in our judicial system, all those things, right?
Oh yeah, I mean, the court needs to be able to work together to share draft opinions, when, after they hold a conference, after the oral argument.
Yeah, you talked to me about this at length the other day. This is really important, not to interrupt you, but I want folks to hear this. Walk me through that whole process in terms of how these justices convene, discuss, banter, debate. Somebody writes the lead opinion, reaction, all of that.
Okay, so
run class here.
Okay, so let me back up even one more step.
Sure.
First, what happens is the losing party in the Court of Appeals or in a state Supreme Court petitions the court to take the case. So they file what's called a petition for a writ of certiorari to ask the court to hear the case at all. And the court has discretion about what its docket looks like. Unlike most state and other federal courts, the U.S. Supreme Court gets to decide what cases it takes. So it reads the petition, and it decides, is this case important enough for us to grant cert on, that is, to decide to hear. So it takes 4 justices' votes to grant cert. And that's how the court took this case. So it took 4 justices to decide that this Mississippi decision was important enough that the full court should hear it to review the constitutionality of that Mississippi law. So then they get briefs, and then there's an oral argument. The parties appear, and they argue before the court. And then usually the week of the oral argument, the justices meet in conference, which is just literally in a conference room. The 9 justices and no one else meet together in the room, and they go around the table, and they explain what their vote is going to be, and usually what the rationale for their decision is going to be. And then the justice
Is it historically combative? I mean, do we know much about it? Because there's so much secrecy around. If you're a fly on the wall, is everybody getting after each other on these kinds of things?
That's not
how they comport themselves.
No, I don't think so. I think it's a pretty collegial body. They hear each other. They don't, in that setting, they don't usually try to change their minds, or they're not very fiery. By then, they've already made up their mind. That is, there may be some room to change what the rationale is, or there may be, it's possible for a justice to identify that another one is still in play, and maybe they could be convinced, but they're not going to do it in the conference room. They're just explaining where they're at and what their vote is at that point. And then the justice in the majority, who's the most senior justice, assigns who's going to write the opinion. And if it's an opinion where the Chief Justice is in the majority, he gets to assign the opinion. Otherwise, it's the most senior. So in this case, after the argument in the Mississippi case, which is called Dobbs versus Jackson Women's Health Center, the justices met, they voted, and from the leak that was made to Politico, they voted at that time, 5 justices voted to overturn Roe. That was going to be the ruling, and Chief Justice Roberts didn't vote to join that opinion. So that meant the most senior justice, which is Clarence Thomas, assigned the opinion, and apparently he assigned it to Justice Alito because the leaked opinion is written by Justice Alito. So then he circulates a draft, once he's assigned that opinion, he circulates it to the full court. Anyone can then comment on it, and the others who had voted in conference to join the opinion can say, I'll join it as it is, or they'll more typically, they'll give comments. I'll join it if you tweak this language, if you add this footnote, or if you tone it down, whatever it takes.
And so we don't know whether there's another draft. We don't know whether that process of tweaking, so to speak, actually occurred, because the draft reportedly is from February.
Right. Well, we didn't know until 2 or 3 days ago. There's another leak in Politico, assuming that this is accurate, and I think we can assume it's accurate given the accuracy of the previous story about the leak. Politico reported 3 days ago that there has not been another draft circulated, and that the February draft is the only draft in circulation. Again, typically what would happen, comments would be given to the lead author, and then maybe Justice Roberts would circulate his own concurring opinion and hope to pull off one of the other conservatives who had voted to overturn Roe to try to get them to sign on to a narrow opinion. But according to this new leak from a few days ago, there has not been another opinion circulated. So the only opinion that's out there is the draft opinion from Justice Alito.
All right, so wrapping up the leak, we could talk about the leak all day long. It's we have turbulence in the studio.
I'm used to teaching on Zoom. This happens all the time. Usually there are dogs running across
Phones
the screen
go
right
off,
now.
buzzers go off. In terms of where we are in processing what we think has happened here, you're pretty certain that no justice moves on this. Have you spent any time taking a shot at who had most motive to leak and why?
I can only speculate. I mean, there's been some new reporting in SCOTUS blog. Tom Goldstein has his own speculation, no relation to me, that is. His.
See, you can paint a picture. You could paint a motive for anybody to do it for any reason, right?
Yeah, I mean, I think that the conventional wisdom, and it's probably right, is that it was somebody associated with one of the more liberal justices has a motive to leak. Because in order to show the country what the opinion could look like how extreme it seems to them this draft opinion is, to try to get some public backlash against the draft opinion. But there had been, again, the SCOTUS blog reporting shows that there had been a previous leak that showed what the vote was, and that the Chief Justice was trying to peel off one of the concerns. So it could be that this leak is, I mean, again, this is all speculation, is to try to show, what Roberts is trying to dissuade one of his colleagues from joining.
Right,
what is really, I mean, a very, in my opinion, extreme anti-abortion opinion. That's what they're trying to say is, that is, the opinion is very stark. It, doesn't say reasonable opinions on each side.
Right.
That doesn't say...
It's hardball.
Yeah, no, the draft is, this, Roe is wrong, it's egregiously wrong, it's as wrong as anything the court has ever done, and we have to bury it. And, and that's a pretty extreme opinion.
Well, we'll see. My guess is the public, the polling doesn't show the public's that upset right now. I think when the decision finally comes down, that'll change. But I think this is a limbo thing. All right, what the decision actually means, don't think it, what the decision actually means, and what happened this week when we come back. Stay with us. Obviously, there's a large group of people on either side of the aisle that are very upset about this. But I will tell you that even on the radio, Professor, the initial reaction was something, but it's already dissipated. People are just uncomfortable with this debate. Thought it was put to bed one way or the other. And I'll tell you, pro-life folks who don't want to see the country broken up have some real dilemmas, like me. I mean, I'm a naturally pro-life guy. But I think I've relegated myself to a place where I'm going to say, listen, I can't force this down anybody's constitutional throat anymore. And what's blowing my mind is the idea that we could have from sea to shining sea, no matter where you are on Interstate 90 or 80, you can legally get an abortion or can't. I never thought we would have something like this in this country. So that's just my exasperation over it. In a couple minutes in this segment, then we'll talk about what happened this week in our next segment. What has this, if this stands, if this leak represents the true vote, and if in the month we get this vote from the Supreme Court, what has it actually done? in the overturn of Roe v. Wade, what has it actually done?
Well, it's a seismic change in American law in many ways. I mean, just start with abortion. I mean, what it does for reproductive rights is fundamental. Just as you were suggesting, a woman's ability to terminate a pregnancy will depend on what state she lives in. I mean, and whether she has the money and means to go to a state where it is legal. So someone here in Rhode Island, where we have enacted a law to protect a woman's right to choose, she'll be able to make the choice about whether to carry a pregnancy to term or not. That decision will be up to her. But if she lives in Texas or Oklahoma or Mississippi, different story. Her right will be fundamentally different. And anyone who helps her to leave the state or get an abortion, they might be a criminal, she might be a criminal. So whether the act of getting an abortion and helping someone to get an abortion is protected or a crime is going to depend on the happenstance of where someone lives and who's in their legislature and who's their governor.
Tell me what happened, though, here, or what potentially is happening, that the court jumped from a decision on a 15-week threshold in Mississippi to a total overturn of Roe v. Wade. That leap is profound.
Yes.
They're not just deciding on a specific state case. They just said, you know what, let's just wrap up the whole enchilada. And let's flip this thing and give it back to the states and let them fight over it, because that's what the Constitution calls for.
Right. I mean, if you're convinced, as the 5 justices who apparently are ready to overturn Roe are convinced, the Constitution just doesn't speak to this question. The Constitution doesn't say one way or another whether a woman has the ability to decide whether to carry a pregnancy to term. That's just not a liberty that's protected by the 5th and 14th Amendment. So we have no business being involved. The court before that had said, well, states can regulate abortion as long as they don't impose what the court had called was an undue burden on a woman's ability to make that choice before viability. The Mississippi law did put that theory to the test, though, because the 15-week ban did prohibit abortions before viability. Viability is usually around 23 weeks. So it did prohibit any abortions, that were pre-viability, and that wasn't an undue burden. It could have been that there were, they could have crafted and maybe they still will, although I doubt it, a narrower opinion that would say, okay, 15 weeks is okay, but a total ban is not. But the justices, there's now a majority on the court apparently to say, we just have no business being involved in this because it just isn't the kind of fundamental right that we thought it was. And that is that the court has been saying is a fundamental constitutional right for 50 years. And now let's get out of this business.
Sure, we have some dozen-plus states that are already triggered. 13 states reportedly that are triggered. As soon as this thing gets voted, bang, they have their anti-abortion laws, if you will, come zooming in.
Yes.
Other states have partial triggers, and then states like Rhode Island and Massachusetts are going to reinforce an opposition to the momentum of that Roe v. Wade thing, right?
Right. I mean, every state will get to go its own way. So some states immediately will reinstate the bans on abortion that existed before Roe. At the end of June, when this decision comes out, if it goes the way that it looks like, abortion will be illegal in many states. Maybe about half of Americans will be living in states where abortion is banned. And that'll happen immediately without any new action by the state legislatures. The state would have to do something new, pass a new law to either protect the right or to prohibit the right or clarify the right.
When we come back, we'll talk about for a couple minutes what happened this week and how does that change things, if at all. Stay with us. So this week, the Senate Democrats tried to get everybody on the hook, make sure that everyone is on it. But as Democrats often want to do, it seems to me they reached and they really loaded up a bill that actually lost them one of their own, Joe Manchin in West Virginia, with all sorts of very aggressive protections for abortion that people who are struggling with this whole thing might have problems with. In other words, any kind of wait times, any kind of ultrasound look, any kind of that kind of a thing. There was no real reference to the term women in the whole thing. There's a whole bunch of things that unnerved Murkowski, Collins on the Republican side, and Manchin on the Democratic side. But my bigger question for you is, on the constitutional level, do you think any federal law will stand? one way or the other? Because aren't we in this kind of boomerang situation where there'll be a contest to a federal law written one way or the other, which will end up where? Right back at the place that this whole turbulence started 2 weeks ago, the Supreme Court. Am I correct about that?
Yeah, I mean, it's hard to know how the court would deal with a federal law that protected abortion or that prohibited it, because don't forget that with a slight change in the House and Senate and a different president, the bill could go exactly the other way, and we could have a national ban. And national Republican leaders are talking about enacting a national ban. So
I don't think they get the stomach for that. Do you? I mean, that'd be a political hat, not a legal one.
Right. I mean, this whole political area isn't my day job, so I'm just
but there is a little bit of dog that caught the truck type of thing going on.
But on
here,
the constitutional question, let's assume that they could pass a law like the one that the Democrats tried to get through yesterday. Although I agree that their goal wasn't to actually pass the law. They knew that law wasn't going to pass. They wanted to put everyone on record because they want the Republicans to own it. That when Roe is overturned, that they voted against it, that they got these people on the Supreme Court. They want them to own it. But let's assume that they pass that law. Would the court uphold it? The court did uphold a national ban on so-called partial birth abortion a few years ago. And the question is, where does Congress get the power to regulate abortion? And the usual constitutional theory is the so-called Commerce Clause. Congress can regulate commerce, and medicine, whether we like it or not, is a form of commerce in the United States. It's not just a protected right, it's business. And so Congress can regulate business. So maybe they can regulate abortion by protecting it in the same way that they can regulate other forms of business. There'd be some questions about how they did it. The Murkowski and Collins bill would institute the undue burden standard that the court has until now adopted as their standard. There'd be some question whether that standard is too vague, or whether there's any standard that would pass constitutional muster. There are not insubstantial arguments that the law would be struck down, and it's possible the court might uphold it. They might say it's political, let Congress decide it. Or they might say Congress doesn't have the power to decide this. Psych, we said it was political. We said that it wasn't our job, but then they're saying it's not your job either. And we saw that back in the 20s and 30s when Congress tried to regulate labor and employment. They said you can't do that.
10 seconds. Where are we going in a month? 10 seconds.
10 seconds. Looks like there will be no constitutionally protected right of access to abortion, and that will have a seismic change in America, not just for women and reproductive rights, as important as that is, and that's fundamentally important, but for gay rights and a variety of other protected rights.
Thank you for coming. Fantastic. Final word next. We're out of time. Stay calm on this issue. Talk to you on the radio 3 to 6.